practice of the profession. So it is not just, you cannot say that you have a perfect bench, you have a perfect bar. We don't have that. We don't even have it even in the US. Some of the lawyers that represented some Nigerians in some cases overseas were jailed.
Will it be good to start, for instance, say in section 171 and get the AGF to interpret what it means? Because this administration is bent on fighting corruption. Will it be okay to start from 171?
Well, the issue of getting the attorney general, that is not, that's part of the reasons why we'll talk about having Minister of Justice and Attorney General. Some of the problems you have there now is mixture of two of them. So the Attorney General is part of the executive. Those are some of the things. So he's responsible to the executive. The Attorney General is like the Accountant General or the Surveyor General, you know, all that. It will be totally within some degree of independence from the judiciary.
What will change if that happens?
What will change is that the Attorney General takes responsibility for whatever action that comes his way, because he will not be going to the executive council. He will be totally a professional with some degree of independence.
Doesn't it take responsibility now? Is he no longer a professional?
No, but then he will also, I mean, we can't sit in a meeting and then you come and say something different, considering the nature of
Isn't the law the law?
Yeah, but that's the law. What I'm just saying the practical effect. When you have issues like the issue of confirmation of Mago and all that, that issue should be taken to the judiciary for interpretation, because there are perspectives to it.
Let me get your thoughts on the so many, over 3,500 election petition tribunal cases that were recorded in 2015 alone. Yeah. That's according to the civil rights organizations. Now, if we have that much, 3,500 cases before the judiciary to look at, be it at the tribunal level or the appellate courts, are we deteriorating further as we move into 2019? Or are we arresting the issues and will possibly have, say, 500 cases?
Now, the point about election tribunals, I participated in the tribunals, and I can talk as someone who has been in tribunals and the election cases, and election cases and all that. Part of the challenge we have is enlightenment. People are not enlightened. They just believe that you say every case that you take to the tribunal. And part of it is what the CJN is talking about. You know you have a frivolous petition. Why will you file it as a lawyer? Why won't you tell the client you don't have a good case?
Because they need to make the money. So how do you
exactly?
Check
that's why he's saying.
How do you check
that's why the CJN is saying, watch your stomach. You must not, because of money, do every kind of thing. The more you file the petitions, the more you burden the tribunal, the less effective they are.
But aren't they doing that because they can?
No, I mean, because the law, that's the position of the law, that you have a right to petition. And let me get to the next level. INEC ought to take some steps. Take an example. Since after the 2015 election, one of the things that will help our electoral process is the card reader system, electronic voting and all that. We needed to have, by now, put that behind us 2 years after that election. The law should have been set in place. And the single elections coming, you know, this stay they do and all that, undo and all that, would have been done totally on card reader and perfected. When you use the card reader system, it will minimally reduce the petitions to have at least half, because it would have improved so much before the next election. Because election is seen as the next means of employment and riches. Take an example with our legislators. Why wouldn't it be on part-time? Why wouldn't it be on part-time basis and reduce the strive to? So if Mr. A wins election today, when you know he's even a tenant, within 1 year he has 10 houses.
Okay.
The next election, the next neighbor will say, I better die getting this election than nothing.
You know, but if the CJN say that the legal profession is part of the culture of impunity, that's a very strong statement. But when you now say that so many people are being disciplined, but it's not done in public, shouldn't that be reversed?
Now,
especially if people keep questioning the integrity of the
CJN is saying, we realize that what we are doing is not enough. Both at the bench and at the bar, we are going to do more. Those of you that we have not gotten to, warn yourselves. If you refuse, we will get to you and we will not spare you.
What steps do you think the judiciary should be taking to ensure that people see that they're disciplining and re-cleansing the system?
It's not everything about the executive that is wrong.